The next case set for oral argument this morning is Carmen, is it Schoch, am I correct?
It is Schoch.
Schoch versus Jeffrey Schoch. It's case number 18CA011382. Both parties are represented by counsel, so each side will have 15 minutes to present your arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do want to reserve time, let me know and I'll keep track of that for you. If there are minors involved in this case, please just use initials since we are recording the arguments and they are posted on the court's YouTube channel, so we ask that you do that. The court has read the briefs and we are ready to proceed if you are.
Thank you.
Oh, and we use the front podium, I should say, as well.
Okay, very well.
I'm sorry, I should have mentioned that.
All right.
Will you be reserving time?
I will be, thank you.
How long?
5 minutes.
Okay,
I don't believe I'll take that long. So.
you may proceed then.
Thank you. And may it please the court, my name is Attorney David Burda, and I represent the appellant in this matter, Carmen Schoch. I know that the court has read the briefs and read the issues. I will indicate that this is a case which is unlike, obviously, as the court is aware of a typical civil case. When you're talking domestic relations cases, you're talking about a mixture of equity and law. In this case is a very good example of that, and what I believe the court had misunderstood or misdirected some of its ruling on. I'll go in the order of the brief. The parties' date of marriage was 1998. No children were born of issue. Divorce was filed in 2017. The first issue, Your Honors, that we would indicate that the court had erred on is related to the Briggs and Stratton engines and the personal property of the parties. The case was replete with in testimony regarding the Briggs and Stratton engines specifically. There were some exhibits that were contributed to the court which listed a value on the Briggs and Strattons as per the appellee. While my client disagrees with that value, that is important to note that he did place a value on those engines. The court, in its decision, found that because there was no testimony in relationship to what that value would be, and I would even say expert testimony, that the court indicated that each party was to keep their own prospective personal property. On cross-examination of the appellee at the court in that trial, he indicated and admitted that the price of those various engines were varied. Some he paid up to $1,000 for, some less, all acquired during the course of the marriage. And he admitted and agreed when questioned that the value of those is determinative based upon the market at the time. So he indicated, and he agreed, that it may be worth more, some may be worth less. In one point in the trial, he also admitted, upon questioning, that in his own words, the reason the appellant wants those engines are they're worth more than the things she has.
Did anybody ever hire an appraiser to figure out what the value of those engines were?
There was an appraiser hired. The appraiser had showed up 2 days after the court's deadline, and the appellee would not allow that person on the property. So that's where we were. So we had to go into court at that point in time with what we had to fashion a division of property. Now, I understand, and I see the point the court would say, well, what would the presentation to the court be, so we could wrap that up. And that's why the questioning, and I was the trial attorney, was so adamant about what the value of that property was, because I know I didn't have an appraiser. I know I had his valuation of the property, so I had to establish, and it was established on record, what she viewed the property as valued at, what she thought was substantially more than he had placed on the value of that property. And I also questioned him at the time, which is the appellee, on a proper way to divide that property. He did indicate, and he agreed that if the court were to go to a lottery-style auction with 1 and 1 and 1 and 1, that he would be amenable to that, although he wanted to keep all of his property, obviously. In exchange, my client, in the testimony in there, indicated that she had owned some baskets, some figurines, and things of that nature. And that's why the testimony at that point in time went to, what do you believe the value of that property is? Was it greater or less than? And he indicated that he believed it was greater, his value of personal property, although it's marital in nature because it was all acquired during the marriage. The property that he would consider his own. Looking up the case law on this, I believe that this Court of Appeals actually said, absent such a determination that the appellate court is unable to review the property of the overall division of assets, the court is not privileged to omit the valuation altogether. And I would put in this case, There's no evidence presented that regarding my client's valuation of that property, of her own personal property. And the court in this case, I believe, said, well, nobody offered any testimony from third parties, therefore you just keep what you have. I believe that was a tremendous error, especially when so much time was devoted to establishing the value of the property and where that property should in fact lie or should not lie.
Well, whose burden was it to offer evidence of the value?
Well, both parties at that time could offer evidence of the value. I would indicate, and this is why I think it's very important to determine that this is a divorce action. I know, this is.
And did they?
What's that?
And did they?
He indicated, the appellee did indicate a value of the property, which was on, Your Honor, I would be remiss to tell you the exact amount right off the top of my head. On his
But he
exhibit.
did.
He did.
Okay.
He put a monetary value on that, yes, he did.
On the engines.
Yes, he did.
All right.
He did. She indicated she disagreed with that value, but even.
Based upon what expertise?
Other than what she paid during the course of the time period, he indicated some of the value that he placed on that.
No, she disagreed. Based upon what
disagreed.
expertise?
Her expertise was she knows that it was paid for more than that, they paid more.
Okay.
And he indicated that yes, some of them were paid more and they were worth less, some might be worth more. He indicated it was all up to what the buyer was willing to pay, based upon his knowledge as well in that area.
And her items, they weren't just baskets and knickknacks. You were talking Waterford, and which I would call a little more than a knickknack.
Well, perhaps, once again, the value wasn't placed on those, they were in
Did she
dispute.
value them?
She did not place a value, the only indication on the record was she believed the value was worth substantially less than his valuation of his Briggs and Stratton. I keep saying his in the sense of,
I understand, we understand.
but it's marital.
Yeah, right.
So that's how that went. And I indicate to this court, and I think it's very important to note, the court should strive towards the division of property to make the division final. However, the duty of the court, as per case law, is to determine the value of all assets placed upon a dissolution of marriage. This court actually indicated that if the value was not there, that they should instruct the parties to go give me a value. And in this case, I think that's if, at a minimum, the court should have done. And that's why this case was presented in such of a division. Difficult
The
to
court
determine.
has to divide property, but there's no requirement that it be divided evenly between the parties.
No, equitable though. And,
Equitably, but not evenly, yes.
correct, equitable. So the definition is what is equitable. If he indicates that the value of that property may be worth $25,000, I'm using this because I don't remember what it was specifically on one of the exhibits, and I do apologize. If he said it was worth $25,000 or so, and he did indicate a value on that, we would indicate that that's worth substantially more than what she had. And he admitted a lot of her things were just things of nature in baskets and figurines and things of that nature.
You did appreciate they were actually Longaberger baskets and Waterford crystal.
Well, Longaberger, I would say, is probably not worth much anymore. If you look at garage sales, you pick them up for a couple of bucks. But I agree, Waterford, I couldn't answer that one, definitely. Second assignment area, Your Honors, is I believe the court erred when it did not divide the OPERS pension of the appellee between the parties. It's a long-term marriage, I believe it should have, and I argued it went reserved jurisdiction. He indicated he was disabled. We have no issue with that. He indicated, however, that disability is an ongoing issue, so when he is actually retired, in his estimation, he would receive actually less on retirement than he's receiving now, but he had nothing to back that up either way. Neither party did. So the issue on that is whether spousal support should be, the reservation of jurisdiction should continue. If there's no spousal support now, why do you take an asset that's worth substantially that much money, a retirement of 20-some years, and give it to one side completely, based upon the incomes?
Are you suggesting that the court's explanation for doing that was insufficient?
I do believe it was insufficient. There was nothing before the court to tell him how much that was worth. There was nothing before the court to determine how much his actual PDRS payments would be in relationship to his disability payments now. And in addition to that, as I had cited, when you're on disability for such an extended amount of time, that too can become a marital asset. So what the appellant is requesting here is not that spousal support issue, just that that be divided equitably, and we would say half and half, based upon the years of marriage pursuant to a Hoyt formula, and that the court retain jurisdiction, determining whether spousal support is appropriate after that division. So in other words, you take a situation where retirement's worth $2,000, I'm just using this as an example, each party would receive $1,000 at that point, but perhaps my client would be making $2,000 and he would be making none. In that case, my client would have to pay spousal support to him. So she actually could be at a loss there. She may have to pay spousal. But it's such a substantial marital asset to just say, well, one party should receive it and one party should not, I believe was an error based upon the years of marriage. And that is the main asset that they do, quite frankly, have. And most parties do, most people do, that retirement is that important. So
We're
I
at
think,
5 minutes and 30 seconds right now, total left, so you can continue.
all right, then I'll reserve whatever's left. If I have a minute or two, can I do that?
You have a total of 5 minutes.
All right, so I'll just
I'll
touch
just
these
let you know
others.
where you're at.
All right, thank you very much, Your Honor. Also, I touched briefly on the court committed reversible error when it found the marital home to be valued at $124,000. The appellee said it was worth $124,000, but the interesting part about this case is you had an appraiser say it was worth $124,000. I objected to having that appraisal go through because the appraiser was not there. The court clearly says if the appraiser's not there, subject to cross-examination, you can't use that value. I don't know how the court came up with $124,000 otherwise. It didn't use the tax records, anything of public knowledge. I think that was reversible error.
Was that value stated in the parties' affidavit of income and expenses and property when they filed for their divorce?
I don't believe that value was
Would it have been on that form?
It's, and I'll be very honest with you, it's not always used in the court here,
The affidavit of income, expenses, and property is not used in this court?
not often. Usually temporary orders, if it's a contested hearing, they'll use it, otherwise not always. And in this case, I don't believe it was.
Did someone testify to a value of $124,000?
He indicated he thinks it's worth $124,000. He had no,
He
he
being the
meaning
husband?
the appellee,
Okay.
and the appellant, my client, said she thinks it's worth more because based upon the improvements.
Was
Yeah.
that testimony stricken in any way or asked to be stricken?
It was not stricken, it was his personal testimony. Obviously, the court can rely on personal testimony, but I found it odd that the value, because it was discussed in there about how that valuation came, it was exactly the value what the appraiser said. So,
Did you hire an appraiser yourself to appraise the property?
prior to my involvement, there was an appraiser involved, however, that was not completed. I was involved very late in the case. And I will indicate lastly, one argument that I will make is on attorney fees. Indicate that the court awarded attorney fees of $2,500 to the appellee. However, I would argue that that was error and it used its discretion, and namely because it didn't indicate why. It just said because she dragged her feet, because the litigation was ongoing. And I will indicate to you, this court, prior to my involvement in this case, there was not even a court date set for a trial. The first thing I did was get a trial date. So I don't know how you can blame my client on that. That would be a court problem if they're not maintaining their docket or getting a trial date. I will reserve any other time I have.
You have 3 minutes and 10 seconds.
Thank you. Thank you very much.
Good morning, Your Honors.
Good morning.
Please the court. I'm Pamela McAdams here on behalf of appellee Jeffrey Schoch. And I'd like to address briefly each of appellant's 5 assignments of error. The first of those is the personal property issue, specifically the engines. The trial court has broad discretion in dividing personal property. The division need not be equal, it need only be equitable. This is a premise repeatedly asserted through Ohio Supreme Court rulings, as in Bisker versus Bisker, Barish versus Barish, and Cherry versus Cherry. Carmen Schoch sought to obtain a court order to value the personal property, and she got that court order, but she didn't avail herself of the opportunity to use it. So now she comes to this court complaining about the lack of valuation, which is due to her own actions. The trial court found merit in not selling or dividing up collections. Collections have greater value when they're left as a unit than divided. In order to retain that greatest value, the court identified in its court order that each party would retain his and her own collections. According to the Ohio Supreme Court in Barish, the trial court is vested with broad discretion to develop a measure of value. Appellant asserts that there was no value evidence presented nor found by the court. That's simply untrue. The parties testified to their personal property issues using in part a multitude of exhibits with listings and values on them. Of the items listed in those exhibits, some were awarded by separate orders, some were agreed upon by the parties as to how they were divided, and others were to be lotteried where they weren't divided or agreed upon. The court heard and properly relied upon testimony from each party as to the value of the personal property, and it was divided equitably. It was not precisely equal, and the court found at page 29 of its order that there was about $440-some difference between the two values of what she got and he got. But I would assert that in balance, Jeff was ordered to pay a number of things and lost a couple of things that far exceeded that $441 value. Specifically, he was ordered to be the one to, spend the money to Qdro his deferred comp account, and that's more costly than it is than $440. The parties had handled their household finances separately throughout their marriage. They never really commingled their assets and income. So for him to keep his property that he acquired and she to keep hers was quite equitable. Per Blakemore, this court shouldn't substitute its judgment for that of the trial court unless you find that the trial court's decision was unreasonable, arbitrary, or unconscionable. In each of the cases cited by appellant on this assignment of error, there was literally no value testimony or evidence of any nature. In Willis, there was an unvalued pension fund, and in Wenger, the court was offered no evidence whatsoever, yet was asked to divide employment benefits. That wouldn't have been possible. It was possible in this case. These are very distinguishable from the case that you are hearing today. With regard to the second assignment of error pertaining to the OPERS account, the Supreme Court in Hoyt held that when considering a fair and equitable distribution of pension and retirement benefits in a divorce, a trial court is to apply its discretion based upon the circumstances of the case, the status of the parties, the nature and terms and conditions of the pension or retirement plan, the reasonableness of the result. The trial court should attempt to preserve the pension or retirement asset in order that each party can procure the most benefit and attempt to disentangle the parties' economic partnership at the conclusion of their divorce case. Every aspect of Hoyt was followed by Judge Janik. Each of these parties earns similarly, and in fact, she earns more than he, because in the year that the evidence was taken is the year subsequent to when Jeff went on disability, and he had some accrued leave of a little over $7,000 that he acquired in the year at issue. That, combined with his disability, put his income at approximately hers. Without that accrued leave, his income is less than hers. When Jeff's disability converts to retirement, it'll be less income than disability income.
Was there evidence of that submitted?
Only testimony, Your Honor. It was not possible to obtain numbers from PERS, but my client did learn from PERS that when he retires, it will be less, and that's a fact that in my experience is a fact. So it'll be less. So to abide by the rulings of the Ohio Supreme Court, Judge Janik properly decided to permanently disentangle these parties rather than see them back into litigation in a few years. The trial court both preserved the pension to provide the greatest benefit and to disentangle the parties. The court found, with good reason, that each party earns similarly, that on conversion from disability benefits, Jeff's income will be less than Carmen's. Jeff has significant health issues and will not return to work, whereas Carmen is young and healthy and a self-proclaimed workaholic. The division of other assets offers Carmen the opportunity to save for her retirement when she will also receive Social Security benefits. Jeff will be and is now entirely reliant upon his OPERS as his sole source of income. These were all the findings of the trial court. This was not a random, unthoughtful decision. Thus, after thorough consideration of all the factors and the guidance offered by Hoyt, the trial court correctly awarded the OPERS account to Jeff. And I would say, although it's not in the judge's order, that there's another reason he may have done this. This was difficult litigation. It was a simple case, but there was a great deal of non-compliance, lengthy trial over a marriage that had all ascertainable values, and it went on painfully long, and I suspect that Judge Janik anticipated we don't want to be back here with this couple. As it relates to the third assignment of error, that is the house value, this very court has ruled on the identical issue raised in appellant's third assignment of error. And that is that his assignment is that the trial court erred in using the appraised value when the appraisal wasn't admitted. Your ruling, Your Honors, in Solberger versus Solberger was that an appraised amount with no other appraisal being offered is not error in using the appraised value even when the actual document isn't in evidence. Carmen selected this realtor. Each party testified that he appraised at $124,000. Your Honors asked whether there was another appraisal or an objection. No, there wasn't an objection to each party testifying to that dollar amount. In fact, the appellant raised that dollar amount in her own testimony, as did appellee. She did not get a new appraisal when she disputed this one, even though there was plenty of time to. She asserted her own unsupported opinion of the value, but simultaneously disputed that she would ever buy the home from the appellee for the price she says it was worth, and also asserted that the trial court should not rely upon her opinion of the value. Her dissatisfaction with the appraiser led her to post poor comments online to the appraiser's website, and I suppose that's why he didn't show for a validly served subpoena. Not that I'm excusing that behavior, but I tried to reach him, the judge's bailiff tried to reach him and gain compliance, but he didn't show up. Regardless, while she objected to the admission of the written appraisal, she never objected to the testimony about it. In fact, she offered testimony of the $124,000. The trial court heard that dollar amount from each party and properly used it. With regard to the fees, Revised Code 310573 is a statutory authority providing jurisdiction to award fees in a divorce case. While appellant argues that the court provided no reason for the award, that's simply not true. There are 2 pages in the judgment entry of reasons. They appear at 33 and 34 of the judgment entry. It was her conduct that resulted in the escalated fees, not commensurate with the value of this case. The court found that the wife had engaged in misconduct. She went through 3 lawyers and didn't provide responses to repeated settlement proposals. She hid her husband's jewelry out of state in her son and daughter-in-law's care. She destroyed assets. She came to the marital home despite restraining orders and did damage. Her failure to abide by court orders and non-responsiveness to discovery led to trial difficulties. A meeting was set at her request at a time when she was between counsel. She chose an inconvenient location in the dead of winter and had my client and I meet her there. And it was just a day or two's notice, but we said, yes, let's do it. We need to get this over with. My client has difficulty walking. He traveled out on the ice, and he and I sat in the window of a restaurant and watched her pull in and pull back out. And she didn't come in for the meeting. The court heard that testimony. It was a waste of my client's resources and my time. There was only a very small amount, $2,000 of attorney fees awarded. I think it was compensatory. I think there was valid reason for it. I submitted a fee contract, an itemized fee bill, and testimony as to my services rendered. And at page 34 of the judgment entry, Judge Janik found them necessary and reasonable. The last assignment of error is that regarding the pole barn as separate property of the appellee. This appellate court has previously ruled that the trier of fact is charged with the responsibility of assessing credibility of witnesses in Moden versus Moden. Appellant argues in her brief to this court that no evidence was presented as to the investment husband made in the pole barn from the sale of a premarital barracuda. To the contrary, Your Honor. Husband testified that he sold his premarital car for $25,000 and he put 100% of that money into the building of the barn. His trial exhibit Y were the receipts for the construction and the supplies and the contractors. Both parties testified that the car sold was a premarital asset. There was dispute as to how much he got for it because the buyer was deceased by date of trial and there were no receipts. It was quite a ways later. The wife testified that she contributed monies to the pole barn and that her car was sold, that the car, his Primero car, was sold for $18,000, not $25,000, but she hadn't an iota of proof of that. Appellant's brief also asserts that the equity line of credit is relative to the pole barn. That's not a fact. There was no evidence whatsoever that there was a link between the barn and the balance on the line of credit. The line of credit, though, under the existing order becomes Jeff's responsibility. At page 18 of the decree, the court found wife's testimony not credible and found husband's testimony credible. The court found husband's separate property traceable. Given all the facts and circumstances and the evidence, this court should defer to the judgment of the trial court absent a finding of abuse of discretion, of which I believe there was none. In general, Your Honors, the trial evidence was that Carmen's credibility was questionable in many areas. For example, her expenses far exceeded her reported income, and yet in another place she testified to much greater income than her tax returns demonstrated. Despite 3 witnesses testifying to the contrary, she absolutely denied taking the appellee's jewelry and hiding it with her children out of state. Her statement that the pole barn was constructed from her resources was entirely unsupported. She arranged the settlement meeting, which I already described, which was just an exercise of poor judgment and waste of people's time. She removed items and she damaged the marital home and personal property in violation of restraining orders once the appellee was given exclusive possession of the property. She disputes his value on the engines, but she failed to avail herself of an opportunity given by court order to get herself evaluation. And she didn't ever provide sufficient discovery to even subpoena bank records, so we went into trial without even knowing what her assets were. All in all, Your Honors, there is no error of the trial court of the nature she brings to this court, and appellee asks that the rulings of Judge Janet be upheld. Thank you for your time.
Thank you as well. Counsel, you'll have 3 minutes and 10 seconds for your rebuttal.
Thank you. Your Honors, in relationship to the argument number 1, if you look at the record, and it's in my brief on page 9, appellee indicated upon questioning the numbers next to all the engines in the inventory listed in the exhibit did not represent the values of the engines as some of the values have today. Some have gone up, some have gone down. He admitted that there are hundreds of engines. He paid $1,000 an engine for it. Most importantly, if you look at how the court determined the value of that engine and its exhibit, it's attached to the Court Exhibit A, to its judgment entry, the court valued the engines at 0. The court valued the Longaberger baskets at 0. The Waterford Crystal at 0. Everything is 0. And it also, very interestingly enough, into my second assignment of error, valued the OPERS at 0. Your Honors, it's simply not 0. And that's why this based upon the circumstances, the appellant asked that the court retain jurisdiction once that was dispersed, and then revisit spousal if necessary. In other words, split up the actual amount of OPERS. It was difficult to determine, and appellee admits that, the value of OPERS until it's actually dispersed. So for the court to say, actually it's $0 worth, I think it was relying on, well, there was no evidence that presented. And actually, if the court uses that analogy, there was evidence presented in on the engines, at least from the client's side of the appellee in this exhibit. He indicated, and as I said, and I do apologize, $20-some thousand valued on those engines at the time. But it apparently didn't find his testimony credible either, because it valued it at 0. Everything was 0. And I think, Your Honors, that's where my main argument thrusts. The court did not determine the value of this necessary property. That's why we said it should have been divided if there couldn't have been placed a value upon it. And OPERS should have definitely been, in fact, split equitably and then maintained for a later time. I think based upon those 2 errors alone, that this case should at the minimum be remanded back to determine the value of that property and or the OPERS to determine whether it's credible to actually have the court do that. Whether a Cudro group can actually, I'm not sure if they can, to be honest, determine the value of that OPERS in the future. So I believe there's a reversible error in this case. Thank you.
Thank you as well. Actually, thank you both for your arguments today. The court will take the matter under advisement, issue a decision in due course. Once it's released, the clerk of courts will mail each of you a copy of the court's decision. You can also check the Supreme Court of Ohio's website, which also posts the decisions. Thank you again for your arguments.